Hello, 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 hello. As you all enter, make sure you hit that like button. I truly appreciate it. I don't know why I'm seeing so dark in here. Yeah, okay. My shirt is kind of plain. But anyway, that's not why we are here. We are here because I'm going to go over this recent lawsuit. Looks like Drake can't stay out of the being sued. He started it and I guess somebody else is going to continue to finish it. So this has something to do with recently. So like I said, as you come in, make sure you hit that like button. You see it above my head. There is a QR code, and also below this stream, you'll see all my social media handles. I am more active on Twitter, and I'm trying to be as more active as Facebook because I do want to stream on Facebook. So join my Facebook page, and then that I think I need 1,000. I don't know how many people I need over there at Facebook to be able to stream live on Facebook. But help a sister out. Help a sister out. All right. So what are we talking about today? Let's get into it. So Drake faces a copyright infringement lawsuit. And let me share this tab with you all. And this is from the double XL. Here it is. I need to click that off. All right, here we go. Double XL. Drake faces a copyright infringement lawsuit over What Did I Miss video. And that was a video that happened after the beef. So I think that What Did I Miss video came out earlier this year. So this came out after the beef. So what I'm going to do is give you all just an overview of what happened, what's happening. And then we're going to go into the lawsuit. It says he's been hit with a copyright infringement lawsuit over his music video for the track, What Did I Miss? On Wednesday, November 12th, photographer Gabrielle Gillamberti sued Drizzy in the United States Court for the Central District of California. The lawsuit accuses the OVO head honcho of, quote, willful, brazen, and extensive unlawful infringement. Gallimberti alleges that Drake infringed on a photo in his portrait series, The Ameriguns, which shows a family in a pool that's surrounded by various firearms. So they may have a copy. Show you a copy of it. Let me make sure. So this picture right here in the circle, this is the picture that Drake did. I think they have a picture. That's the copy of the lawsuit. Oh, we don't mean to do that. Let's get out of here. So this is the picture. This is the picture that he had. I was trying to see if they I may have to go look for it real quick so that you all can see this. All right. Let me share this screen. All right. This photo right here in the corner. You see this photo right here in the corner. This is the photo that they're saying that Drake copyright infringed, with all of the guns around the thing and the families in the pool. This is the photo that they're saying that he has a series of different photos, as you can see. He's got this photo with the families with the guns lined up here. He's got the series of the man lined up around his guns here. You have the photo with the lady with her guns lined up here, and so on and so forth. He has so many guns, he can outline the state of the United. He can outline the country with it. So I wanted you to get a visual of what he was talking about. Now let me go back to Drake's picture. That's here in the corner right here. Is it right here? Versus Galimberti's picture right here. So this is what he is suing for. Okay. All right. So let's get into the lawsuit. It is 13 pages. We will zoom through this. Not a problem. All right. Let me close all these other tabs. All right. As you can see it here, I want that to be bigger for y'all. Here we go. So, excuse me. So this is the Valkyrie Law Group. Heather L. Blasey, Esquire. She's the attorney for Gabrielle Galimberti, and they're suing Aubrey Drake Graham, OVO Sound, Republic Records, and Universal Music Group. Again, it was filed here, as you see up here at the top. It was filed on 11/12/2025, and they are demanding a jury trial. And the complaint is for copyright infringement. It says here, plaintiff Gabriel Gamberti, an individual by and through his attorneys, Valkyrie Law Group, and for his complaint for copyright infringement against defendants Aubrey Drake Graham, an individual, OVO Sound, an Ontario company, Republic Records, a New York company, and Universal Music Group, a Netherlands corporation, and those 1 through 10 collectively are the defendants, alleges as follows, and this is the nature of the action. This lawsuit concerns defendants' willful, brazen, and extensive unlawful infringement of plaintiff's exclusive copyright in his photographic portrait image, the original work, contained within the project entitled The Ameriguns, the original work, and hereon known as the project, which was created by plaintiff Gabrielle Galimberti. That Galimberti's iconic and highly distinctive folk photography style embodied in the original work was lifted by defendants to set the scene of the music video for the song What Did I Miss? The infringing video is both an egregious violation of federal law and an affront to plaintiff, his livelihood, his legacy, and to photographers everywhere. So first, artists are having to worry because copyright infringement and all this other stuff has been going on for forever. But now what artists have to face is AI and how AI is sucking up your stuff. You know, now screenwriters are having to worry about AI because all AI is going to do is go through several different stories that have gone on through the world and then compile from those different stories. Uh, and then they'll take your work as a screenwriter. AI is taking actors' job as actors. They are running around here creating images of people. And my issue with that is always that what seems to be the only thing that these current AI people who are creating works can do is to do scenarios that are mimicking the stereotypical behavior of black women and exacerbating it by 1,000. And these are the things, and it's unsettling. It is unsettling, and I don't like it at all. There's nothing wrong with you using AI to help you research, help you formulate ideas, help you do those things like that. But when you're using it to be uh, denigrate to other people, I have an issue and a problem with that. And I know that was a side note, but I just this copyright infringement and AI seems to kind of go hand in hand for me. Plaintiff is an internationally renowned photographer whose work spans over 20 years. Plaintiff has produced numerous reports and articles for publication around the world, as well as books, exhibitions, and conferences. So he's laying out the framework that he is that dude. Plaintiff has been a National Geographic photographer since 2015. That's 10 years. Plaintiff has earned multiple prestigious awards throughout his career, including the World Press Photo 2021 Award in the Portrait Stories category with the Americans. So he is an award-winning photographer, and the piece that he's saying that Drake pulled from is the category that he won, the Americans. Plaintiff works consist of long-term projects investigating the habits of people around the world, including but not limited to their differences and similarities, peculiarities, and fears. Plaintiffs is recognized by his distinct photographic style. He has repeated several times throughout his career that involves portraying a person and their objects all arranged in a very precise geometric layout in front or around the subject. Plaintiff employed this particular style in the Ameriguns project, which consists of a series of 40 portraits taken of U.S. firearm owners posing with their guns. And you remember we saw that. You saw that man who had so many guns, he was able to do the outline of the United States of America. And side note, usually gun owners in the United States of America, they usually have from anywhere to 5 guns. They usually have 2 to 3 handguns and 1 to 2 rifles. Without the consent of plaintiffs and without his knowledge, defendant infringed upon his right by creating an entire music video scene featuring an unauthorized copy of the original work in the infringing video. Below left is the original work. Below right is a still image from the infringing video. As set forth more fully below, the scene from the infringing video initially copies the original work and is a blatant attempt to appropriate not only the immediately identifiable and unique look and feel of the original work, but also many of the specific copyrightable elements in the work, including arrangement of the weapons on the ground, all parallel, the position of the subject on the right side of the frame next to a swimming pool, the portico behind the subject, the proportions between the space occupied by the composition of the weapons, the swimming pool, and the portico, and the sky. The green lawn area visible on the left above the swimming pool, the shape of the roof of the house behind the subject, and the backlighting with the sun high behind the subject's left shoulder. So let's look at this. This is a still video. This is a still version of Drake's video. This is the original art. So they have the house, they have the person, they have the guns all parallel. Here's the pool. There's the grassy area. There's the grassy area. The only thing I see different is the fact that there's nobody in the pool. And instead of Drake with fire, he's dancing around the guns. Who was the music director? Who came up with the concept? Sorry, y'all. Who was the music director? Who came up with the concept? Is this a full Drake production? The entire theme of the infringing video is premised on plaintiff's The Ameriguns Project. Telling the infringed video was released on July 4th, 2025, American Independence Day, to add further relevance to the title of the plaintiff's The Ameriguns Project and to imply on information and belief that the infringing video was made in collaboration with the Americans Project and or its author, plaintiff, and its author, the plaintiff. The display of the firearms in the scene in the infringing video so clearly a copy of plaintiff's original work that even before the infringer became known to plaintiff, several social media commentators and consumers began associating the infringing video. And so they talk about the reference here. They've got Jay Nolan's name on here. He is a YouTuber. So yeah, they peeped it way back then. Defendant Aubrey Graham is professionally known for implying hidden meanings in his lyrics and audiovisual works meant to accompany his music. On information and belief, defendant Graham also selected to affiliate himself with plaintiff's original work for an additional reason, namely that plaintiff was publicly vilified for his role in a controversial Balenciaga advertisement involving false allegations of glorifying PDF files. I'm going to read that again because sometimes when I read things, I don't have the clearest context until I have to read it again. On information and belief, defendant Graham also selected to affiliate himself with plaintiff's original work for an additional reason, namely that plaintiff was publicly vilified for his role in a controversial Balenciaga advertisement involving false allegations of glorifying PDF. All right. So this was something that looks like it happened in 2022, 2023. I'm just going down here. So let's look at this. This is WWD. Balenciaga responds to campaign controversy. Photographer detail how it's rocked his life. A Milan-based photographer, Gabriele Galimberti, says he received thousands of personal threats. Oh, we can't read the story. Let's go back. I guess because it's so old. Let's see what the Guardian says. I can't read this story. Yes, I can. Okay. Gabriel Galimberti says that he had no input into objects used in image and brand delays, and apologizing led to further abuse. Galimberti, the photographer who took pictures of children carrying teddy bears wearing S&M outfits for Balenciaga's recent ad campaign, said he has received death threats in the aftermath of the scandal. Let's see if they'll tell us. Balenciaga apologizes for ads featuring bondage bears and child abuse papers. Gross. Brand admits grievous error after backlash to campaigns that include images of children holding BDSM teddies. The luxury fashion brand house Balenciaga has apologized over adverts that show children holding teddy bears in bondage gear and others featuring documents about child SA. I don't want to go on with that. But this is what he's talking about. This is the controversy that happened, and this looks like it. This report was written Tuesday, November 2022. So this is what he's referring to in this lawsuit. Plaintiff was immediately publicly vindicated in the defamation lawsuit abroad related to the false accusation arising from the Balenciaga advertisement. Now, the one thing I don't like about that, and everyone, Balenciaga and all these houses want to apologize. I need for you all to know and to understand and be very clear about this. They already know what they're doing is inappropriate or stretching the envelope because they have so many checks and balances in those situations. The whole situation goes beyond the fact that they don't care. They rather ask for forgiveness than permission. They rather ask for forgiveness than permission. So a lot of times when you see all of this going on, a lot of times when you see all of this stuff going on with these houses, because I remember it was Gucci, I think, with the Sambo monkeys with the big red lips. If it's anything, these fashion houses know exactly what they're doing with their campaigns. There's a lot of checks and balances, but they go under the premise that I rather ask for forgiveness than your permission. During the initial Balenciaga scandal, media articles, websites, posts, and news segments would display plaintiffs' photographs from the Ameriguns project alongside plaintiffs' photos from Balenciaga ad. Given Kendrick Lamar's lyric directed as calling defendant Graham a PDF file and defendant Graham's now dismissed defamation lawsuit on information and belief, defendant Graham sought to imply that, like plaintiff, would be publicly exonerated. Okay. So he's okay. Okay. So basically, what he's trying to say is that Drake was hinting with his homage to the Ameriguns collection that, like, just like the person who created this art and was vindicated from any PDF file allegations, he too, talking about Drake, was going to be vindicated from these PDF file allegations. Plaintiff is a serious professional addressing serious themes. His work hangs in galleries, museums, graces serious print literature, and his career depends upon the respect and admiration of dealers, collectors, and critiques of contemporary and documentary art. By the forced and unauthorized association of his work with the infringing video, the integrity of his work and his reputation as a photographer has been damaged. Accordingly, as set forth by more fully below, plaintiff seeks damages and equitable relief for the direct, contributory, and vicarious copyright infringement arising from the creation and the unlawful use of a substantially similar copy of his original work in violation of the United States Copyright Act, 17 U.S. Code 101, U.S. Code Section 101, the Copyright Act. So it goes in his parties and jurisdiction. It says that he's an Italian citizen and he lives in Italy. Defendant Graham is known professionally as Drake. He's a Canadian rapper. He has homes in Toronto, Ontario, in Toronto and Ontario, Canada, Houston, Texas, and United States. OVO Sound is a Canadian record label, music production, and entertainment company organized and existing under the laws of the province of Ontario, Canada, which is principal place of business. Upon information and belief, OVO Sound is engaged in business of recording, producing, da 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 da. At all relevant times, OVO Sound has derived substantial revenue from the commercial exploitation of copyrighted musical works. At all relevant times, OVO Sound has derived substantial revenue from the commercial exploitation of copyrighted musical works and sounds of recording in interstates and international commerce, including sales, streams, and public performances such as works within the United States. Accordingly, OVO Sound has purposely availed itself of the privileges and protection of the U.S. copyright law and is subject to the jurisdiction of the judicial district. They talk about Republic is based out of New York. Universal Music Group has a headquarters. Okay, because I was trying to get to how did they get to California versus being in New York, and they're saying that their headquarters is located in Santa Monica, California. Okay, that's all I need to know. Just wanted to know how they got there. So let's get to the relevant facts to all counts. So again, they're suing out of California. They're saying that UMG is the big operator of all of this, the payer of the videos and all of this stuff, and they have headquarters in Santa Monica, California. So they're going to be in Santa Monica, California. the Middle Central District of California. I guess that's where Santa Monica is. So that is how they got their jurisdiction over there out there in California. Facts relevant to all cases. Let's get to this. Plaintiff in the original work. Plaintiff is an Italian citizen and is domiciled in Arezzo, Tuscany, Italy. Plaintiff's original work was first published on April 24th, 2020, in a magazine publication called Seven, which comes out on Fridays as a supplement to the Italian, uh, oh goodness, Corriere della Sera newspaper, and which was not simultaneously published online. As a result, the original work is exempt from filing for United States copyright registration under 17 USC 104. See also the Berne Convention for the Protection of Literary and Artistic Works, 1886. As a result, plaintiffs, as a result of plaintiff's commercial success in the Ameriguns project, including specifically the original work, plaintiff and the project were widely covered and praised in the U.S. and foreign press. Plaintiff was interviewed several times about the Ameriguns project by U.S. News Channel, including an interview with CNN following the May 24th, 2022 Robb Elementary School shooting in Uvalde, Texas. Defendant Graham resides, at least in part of the time, in Texas. As a result of the wide public coverage and notoriety of the Ameriguns project and the original work in particular, defendant had access to the original work. So they're saying just by sheer fact that he is housed in Texas, there was a school shooting in Texas. He had been interviewed on several different places, and he had also, particularly CNN, and he also had been interviewed in other publications. He believes that the defendant Drake was very familiar with his work. Plus, he threw in there that Drake always be copying and having ghostwriters. I caught his shade in that last. I caught their shade. He's saying he's used to doing it. He's used to taking other people's work and making it his own. Now, what am I referring to that? Because I know within the beef, they were talking about XXX Estacion, the young man that was killed coming out of the car dealership a few years back, and they were saying that Drake had taken his style, how he rapped, how his style of rap, that Drake had taken that style. And then we started seeing Drake wherever he was going, whoever he was collaborating with, he would morph into that style. So he's making a it's a shame that people are making shots at Drake through a lawsuit. The infringing video. On July 4th, 2025, American Independence Day, the infringing video was released by defendants as part of a live stream premiere on YouTube's live stream. The infringing video, entitled What Did I Miss?, features defendant Graham rapping about his public feud with Kendrick Lamar in front of a display of guns designed to be substantially similar to an image from plaintiff's The Ameriguns project. The infringing video is 4 minutes and 2 seconds long and consists of 1 minute and 37 seconds featuring defendant copy of plaintiff's work. The infringing video is available, and it gives the site that it's available. As of the date of this filing, the infringing videos has 19 million over 19 million views on YouTube. And defendant Graham has 31 million YouTube subscribers. On information and belief, defendants have earned significant income from the monetization of the infringing video on social media platforms, including YouTube. Plaintiff was alerted to the misuse of the original work in the infringing video by acquaintances who were surprised to see what they assumed to be his willing participation. Plaintiff has suffered and continues to suffer from the infringing activities of the defendant, including without limitation from defendant's usurping of plaintiff's right to control the publication and commercial use of the original work. So he's basically saying he's around chilling in his Tuscany villa, and folks are coming up to him talking, "Lord, man, I didn't know you allowed Drake to use your concept for his music video." Don't know if they said that it was dope or not. But at this point, Drake, break this man off a little change if he can prove that you need to break him off a little change. Plaintiff has suffered and continue to suffer from the infringing activities of the defendant, including without limitation from defendants usurping a plaintiff's right to control the publication and commercial use of the original work. Defendants' failure to pay any licensing fee, commiserate with the value of their video and promotional use of the original work and its or unauthorized copies, and defendants' failure to account for or disgorge the profits directly and indirectly attributable to their misconduct. In addition, defendants' action have caused significant harm to plaintiffs and the original work, thereby significantly damaging the value of the original work, all of the plaintiff's other work, and the value of any license for his photography in relevant markets. So, in other words, he's feeling like because that Drake did this, he's not able to control the licensing of his stuff, so it's devaluing his stuff. Because people are like, well, I just have to I can pull the image from Drake's video, I can take this from such and such and such, instead of paying him directly for his work. Thank you. How did that? It's X. Let me see. Glue stick said it's XXX Tentacion. Is that it? XXX Tentacion or Xtacion? Xtentacion. How do you pronounce that? Child, a man named Galimberti is suing Drake for that "What Did I Miss" video. You remember that scene that Drake has in that "What Did I Miss" video with all those guns on the ground? He lifted that from a photographer, and that photographer is the one suing it. I got to get this right. X Tentacion. And that's all I'm going with. I can't. I tried, ladies and gentlemen. So let's go to count one. And we're moving along pretty good because we're on page 9. Direct copyright infringement against all the defendants. And remember, they're suing Drake, OVO, Republic Records, and UMG. And I'm not even behind corporations and stuff like that, but UMG and Drake have probably this year, I'm telling you, between the both of them, probably spent upwards to $10 to $15 million in lawsuits, between Drake suing UMG and Spotify and iHeartRadio, UMG having to now lawsuits with Spotify and all. I'm willing to bet you between both of those entities, they have gone off about 10 to 15 million. I think Drake alone has probably coughed up about $7 to $8 million in lawsuits, defending lawsuits. Because I think Drake is being sued because of Kick, him and Aiden Ross. Drake is being sued along with Spotify about streams and being overpaid for streams and knocking out other artists from getting paid. Drake has sued UMG, iHeartRadio, and Spotify. And now Drake is being sued by Mr. Galimberti for copyright infringement. That's a lot of lawsuits to be that is a lot of lawsuits to be involved in. Plaintiff repeats and realleges the allegations set forth in paragraphs 1 through 48 of this complaint as if fully set forth herein. The acts of the defendant constitute infringement of plaintiff's copyright and exclusive rights under copyright in the original work in violation of the Copyright Act. Upon information and belief, the foregoing acts of infringement by the defendant have been willful, intentional, and purposeful in disregard of indifference to plaintiff's right. So basically what we have read so far, and I'll go over what we've read so far of what this plaintiff is saying. He's saying that the plaintiff used his work because, number one, Drake wanted to subliminally suggest that, just like Mr. Galimberti with that Balenciaga controversy that I showed you all earlier, where Balenciaga used children holding bears that were in a depicting BDSM, that just like he was exonerated or proven that he was not a PDF file, Mr. Galimberti, Drake is using his work to convey that same message, that, hey, this person who did this artwork that I'm showing you all in this video and I'm dancing around it, this artist was also accused of being a PDF file in public, and he was exonerated, just like I will be exonerated from being a PDF file, because I am not. And then that's number one, because he was saying that Drake threw a subliminal and put him in some mess that he didn't have nothing to do with. He had nothing to do with the Drake and Kendrick mess. So he was thrown into that. Number two, he used his works and he was not credited. He did not have Drake did not have the appropriate licenses to use that work, and also Drake did not compensate him. So this is what we're going on at this point. The infringement of plaintiff's original constitutes separate and distinct act of infringement. In creating and broadcasting the infringing video, defendants have infringed on plaintiff's exclusive right to make a copy, reproduce, publicly display, publicly perform, distribute, and or create derivative works on the original work. As a direct and proximate result of defendant's foregoing acts, the plaintiff is entitled to actual damages and disgorgements of the defendant's profits attributable to the infringement pursuant to 17 U.S. Code 504. Count 2, vicarious copyright infringement. Plaintiff repeats and realleges everything that happened in paragraphs 1 through 48. The acts of the defendant constitute vicarious infringement of plaintiff's copyright and exclusive rights under copyright in the original work in violation of Copyright Act 17, Section 106. Upon information and belief, the foregoing acts of vicarious infringement by defendants have been willful, intentional, and purposeful in disregard of and indifferent of plaintiff's rights. And so the copyright law 17 USC 106 is the clause that establishes the exclusive right of publication, the right to distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership or by rental, lease, or lending. Under this provision, the copyright owner would have the right to control the first sale. So 17 U.S. Code 502, the Copyright Act, grants U.S. courts the authority to issue temporary and final injunction to prevent or restrain copyright infringement. These injunctions can be served anywhere in the United States and are enforceable nationwide through contempt proceedings and other means. The section specifies that these injunctions can be used on reasonable terms and must be granted subject to the provisions of Section 1498 of Title 28, which deals with infringement actions against the U.S. government. Upon information belief, the foregoing acts of vicarious infringement by the defendants have been willfully, intentionally, and purposeful in disregard of and indifferent to plaintiffs' rights. Count 3 is contributory copyright infringement, and he's doing this under the Copyright Act of 106. Copyright Act 17 U.S. Code 106, Section 106. He's saying that in creating and broadcasting the infringing video, defendants have infringed on places' exclusive right to make copies, reproduction, publicly display, publicly perform, distribute, and or create derivative works of the original work. And they pray for relief. And they are demanding a jury trial. And that is respectfully submitted by Gabrielle Galimberti back on the 12th of this month. So that is what Drake is now being sued for. He's saying that basically Drake has cheapened his brand by putting that video out, and also Drake has inadvertently pulled him into the beef by trying to state that just because of his case or what happened to him in Balenciaga, and he was exonerated of being a PDF file or any wrongdoing because he was not the creative person over at Balenciaga. He was just hired as the photographer. He's saying that Drake was trying to imply that in that video. So what do y'all think about this lawsuit? Now, again, Drake, we're going to have to keep a tally. We're going to have to keep a tally because he started this. And now once these things start, it's always a flood of different people. It's always a flood of information and stuff like that. Because I just and let's see what time it is. So I just dropped a video in regards to Smokey Robinson. You remember earlier this year, four plaintiffs had sued, and they had filed reports with the LA Sheriff's Department in regards to Smokey Robinson, and they are alleging that he has some untoward behavior, some SA behavior, some S battery behaviors. Well, now we learn that there's a fifth and a sixth person. So check out that video and see what's going on with that. That is let me see if I can pull up the thumbnail. So here's the thumbnail for that. We've got additional accusers for Smokey Robinson. Go check that video out if you so desire. And let's see. There is a lot of, like I said, I'm going to do a story on Diddy. Apparently that there is some other information going on. There's an investigation in LA. Diddy also the John Doe in that lawsuit that he had has been revealed. And we're definitely going to do that. We're going to go over that. Also, go back and check out my video about the singer David. He's been identified, not officially, but it is looking like he is about to be identified as a viable suspect in the pruning of the timeline of Celeste Rivas Hernandez. So go check out that video that I have dropped, and another celebrity legal issue video. So I've got this David one. I've got the one with Smokey Robinson. We are always going to stay on top of Drake. Also, I'm going to stay on top of what the investigation in Los Angeles is going on with Diddy, and do a video for that. So that's what I have coming up. Y'all make sure y'all follow me, and you'll make sure that you all are aware of all the things that I've got going on. Okay. I appreciate y'all showing up. I appreciate y'all us going over this lawsuit. What do you all think? Do you think Gabrielle Galimberti has a good case? Do you think that it should go to trial, or do you think that Drake should just cough up 10%, 5% of whatever that he made from that video and get the appropriate license from this man so that video can continue and everybody can continue to make some money? What do y'all think? That doggone Aubrey. All right, people, we do this every week. Please like, comment, and subscribe. Please share this video if you care. Y'all, we will continue to follow this, but I personally think, and along with a lot of these types of lawsuits, I think it's going to be settled, because I think at this point, again, I see Drake and UMG at least spending millions of dollars in lawsuits that they don't necessarily have to spend. Uh, these things can kind of quietly go away and they can get back to the business of making music. But if Drake was complaining about his value to UMG dropping, I can see why, if UMG was thinking that his value was dropping, all of these lawsuits and things like that, they're spending more money than they're making with Drake at this point. They're spending more money than they are making with Drake at this point if they're continuing with all of these doggone lawsuits. All right, people, we do this every week. Please like, comment, and subscribe. Please share this live if you care. Please tell a friend, tell a kin, tell a coworker, tell that helper that you can't stand that I'm over here making these videos. And make sure y'all are hitting that like button. I'd appreciate it. And as always, people, bye-bye.